You may have heard that non-compete agreements are being eliminated across the US, but that's simply not true. In fact, Florida is doubling down on them. Florida just passed a law that lets employers lock you out of your industry for 4 years if you leave your job. So while the federal government is trying to ban non-competes and states like California won't enforce them at all, Florida has become the most employer-friendly state in the country for non-competes. In this video, I'm going to break down this new law called the Choice Act, what it means if you're an employer or employee in Florida, and why it may not apply to you. After watching this, you'll understand whether your non-compete agreement is enforceable and what specific steps to take to protect yourself, whether you're an employer or an employee. My name is Bishoy Habib, and I'm the realest real estate attorney you know. Over the past 13 years, I've closed over 1,000 transactions totaling $12 billion. I've seen countless clients struggle with restrictive non-compete agreements, and this new law is about to change the game completely. So what exactly is the Choice Act? It's a law approved by the Florida legislature in April 2025, and it stands for Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth. The Choice Act takes effect July 1st, 2025, but don't let the friendly sounding name fool you. This law makes Florida the most employer-friendly state in the country when it comes to non-compete agreements. Florida's going the complete opposite direction of the national trend. Here's the most important thing you need to know. Under this new law, non-compete agreements in Florida can now last up to 4 years. That's right, 4 years where you could be legally prevented from working in your field if you leave your job. For comparison, most states that still allow non-competes typically limit them to 1 or 2 years max. 4 years is practically an eternity in today's job market. Let me give you a quick example of why this matters. Last year, I worked with a client named Sarah, a marketing exec who left her job at a tech company. Her non-compete was for 2 years across all of Central Florida. She ended up having to take a lower paying job in a different industry while her career stalled. Under the new law, Sarah's situation could have been twice as long. 4 years of career limbo. That's the difference between a minor career setback and potentially having to restart your entire career from scratch. So this is important stuff. Now, there is some good news. The Choice Act doesn't apply to everyone. It only covers individuals earning at least twice the average annual wage in the Florida county where their employer is based. So if you're making less than that, this law doesn't apply to you. For example, if the average annual wage in Hillsborough County, which is where I am in Tampa, is $70,000, then only employees making $140,000 or more would be subject to the act. The law also includes some basic protections. For a non-compete to be valid under the new rules, it must be in writing, it must give you at least 7 days to review before signing, it must inform you of your right to consult a lawyer, and it must include your signed acknowledgement that you've received confidential information or had access to customer relationships. But here's where things get really tricky. The Choice Act creates what we call a presumption of validity for qualifying agreements. In plain English, that means if your employer sues you for violating your non-compete, a judge is required to issue a preliminary injunction against you if the agreement meets all the requirements we just stated. This would then immediately prevent you from working that new job, and then the burden is on you as an employee to prove why the non-compete shouldn't be enforced. This completely flips the traditional legal procedure on its head and makes it much harder for employees to fight back. That's why we say this is a very employer-friendly law. Even worse for employees, this new law allows courts to punish third parties, like your potential new employer, for facilitating breaches to your non-compete. This means companies might be scared to hire you even if they think your non-compete is completely unreasonable because they don't want to get dragged into expensive litigation. Another wild aspect of this law, it appears to reach beyond Florida's borders. If you work for a Florida-based company but live in Georgia or another state, this law could still apply to you. This raises serious legal questions that'll likely be challenged in court, but for now, it's something to be aware of. So what should you do about all this? If you're an employer, update your non-compete templates to ensure they meet all formal requirements under the new law. Clearly define the duration and geographic scope of your agreements. Train your HR and legal teams on the new rules. Consider whether you actually need a 4-year restriction or if something shorter would still protect your legitimate business interest while creating less ill will with departing employees. If you're an employee or a contractor, never sign a non-compete without consulting an attorney first. Use that 7-day period to review and fully understand what you're agreeing to. If you're a high earner with leverage, try to negotiate narrow restrictions or alternatives like garden leave, where they pay you to stay home rather than work for a competitor. And if you're planning on leaving your job, get legal advice, before you make any moves. I want to emphasize that last point because the cost of consulting with an attorney like myself before signing or potentially breaking a non-compete is minimal compared to the cost of defending yourself in court or being unable to work in your field for years. It's possible we can negotiate the terms of your existing non-compete prior to you exiting the company. Unfortunately, I've seen too many clients come to me after they've already signed problematic agreements or accepted competing jobs, and at that point, their options are much more limited and expensive. Remember, the Choice Act is brand new and will certainly face legal challenges, but until courts weigh in, you should assume the law will be enforced as written. The bottom line is this. If you're a high-earning professional in Florida, non-compete agreements just became much more strenuous. While other states are giving workers more freedom to change jobs, Florida is moving in the opposite direction and more strictly enforcing non-competes. Don't get caught flat-footed. If you like this video and you want to learn more about protecting yourself in employment and business situations, hit the like button. Let me know in the comments what you want to learn about next, and we'll do it. Thanks for watching, and don't forget to subscribe for more videos every week, and I'll see you next time.